welcome to the October 2013 term Supreme Court review. I'm Professor Darrell Miller. I teach civil rights, civil procedure, Second Amendment, and state and local government here at Duke Law School. I am not Neil Siegel, who usually moderates this panel and does it very ably. Professor Siegel sends his apologies. He was unexpectedly called away, so I've agreed to moderate, junior varsity member though I am, and I'll try to do my best in his stead. So with me are my esteemed colleagues, Professor Lisa Kern Griffin, Scholar of Evidence, Constitutional Criminal Procedure, and Federal Criminal Justice Policy, Professor Kate Bartlett, the A. Kenneth Pye Professor of Law and a former dean at Duke Law School. She teaches family law, employment discrimination law, gender in the law, and writes on these fields as well. And finally, Professor Ernie Young, who is the Alston and Byrd Professor of Law, teacher and scholar of constitutional law, federal courts, and foreign relations law. So the format is I'm going to speak for just a couple of minutes about the last term and then open up the floor to my colleagues, Professor Griffin, Professor Bartlett, and Professor Young in that order, who'll speak about 10 to 20 minutes on a case or cases that they've decided to focus on, grab their attention this last term, and then we'll have a few moments for questions afterward. As always, it's been an exciting year up in Washington, where the justices ruled on cases having to do with campaign finance, abortion, religion, federalism, separation of powers, and the Fourth Amendment. Some of the summaries are in the handouts that you got here. And as I'm sure Professor Siegel would say if he were here, Justice Anthony Kennedy continues to prove the crucial swing vote in many cases, forming the vote in such cases as McCutcheon versus Federal Elections Commission, which struck down the aggregate contribution limits of campaign finance law, and Burrell versus Hobby Lobby, which held that for-profit, closely held corporations are protected persons under the Religious Freedom Restoration Act and do not have to have a plan with certain types of contraceptive services that they deem anathema to their particular religious convictions. Although in other cases the lineup was not as predictable, with Justice Stephen Breyer joining the Republican-appointed justices in Schuett versus Coalition Defendant Affirmative Action, a case that had to do with whether Michigan's decision to take the affirmative action policies and ban them through constitutional amendment was itself a violation of equal protection. And with that brief introduction, I will turn it over to Lisa, Kate, and Ernie to identify the case or cases they want to focus on and their gloss on it.
Thank you, and welcome to all of you, and thank you so much for being here to talk about the court's past term. Probably the blockbuster case from the past term is easy to identify, and both Professors Bartlett and Young are going to say a few words, I think, about Hobby Lobby, among other things. There was, though, a blockbuster case of its own sort, couldn't possibly have been more important to criminal procedure scholars, and that is the set of consolidated cases concerning searches of cell phones upon someone's arrest. It's fair to say, I think, in January when the court granted cert in Riley versus California and United States versus Worry, that criminal procedure professors who had just launched into their semesters had to revise their favorite exam hypotheticals. Law students everywhere had to abandon note topics. That has been an old chestnut of law review notes for at least the last 5 to 10 years. And there are few issues that have gotten as much ink in the classroom, in the law reviews, in the lower courts. There was a split between state courts and some of the federal courts about the question whether police officers needed a warrant in order to look at the contents of an individual's cell phone at the time they were arrested. And there are two competing lines of precedent at work here, both of which have very long provenances. One of them is A line of precedent that goes way back to one of the most famous Fourth Amendment cases, Katz, which made clear that the contents of any telephone conversation are private, are protected by the Fourth Amendment, and cannot be wiretapped, for example, without a warrant. And the other line of cases involves the police safety concerns and the possibility of evidence destruction at the time that an individual is being arrested. It's called the search incident to arrest doctrine, and it establishes a presumption that in the undoubtedly extreme circumstances of every arrest, there is inherent risk to officer safety, regardless of the offense of arrest, regardless of the characteristics of the arrestee. And that at that time, officers are entitled to search everything on the arrestee's person, looking, of course, for weapons, but also looking for things that they might easily destroy that would be evidence of a crime later on. And the question for a long time has been, well, where do cell phones fit in? Because they are in an arrestee's pocket, and the court has said, for example, in the Robinson case, you can look in a cigarette pack. We're not just looking for guns. We're looking for all sorts of things. Cell phones are about the same size as that. They have said you can read papers, you can look in journals, you can go through wallets, you can make evidence out of all of the collected things you might find in arrestee's purse pocket and on that arrestee's person. And those things are private, and so too are the things on a cell phone. So where did it fit in? And two cases arose together that allowed the court the opportunity, finally, to consider this issue. The first case is a state case that came from San Diego, and in that case, the defendant, David Leon Riley, was convicted of attempted murder and assault with a semi-automatic weapon after a 2009 drive-by shooting where he shot at an occupied vehicle. And the evidence from his smartphone that he had on his person at the time of his arrest included information identifying him as a gang member, a member of the Blood gang, the Bloods, engaged in a rivalry and the pursuit of vengeance against certain members of the Crips gang who were victims of the shooting. There was a photograph of him with a car that had been seen at the site of the shooting, and there were records of phone calls that he had made from the location of the shooting, all of which came from the smartphone searched without a warrant at the time of his arrest. The case against him, other than the phone, was quite shaky and entirely circumstantial. There were no witnesses, or at least obviously none who came forward and testified. His first trial ended in a hung jury. He was convicted after the second trial and sentenced to a 7-year sentence that was lengthened to 15 because of the evidence of gang activity. And the California Appeals Court, relying on California Supreme Court precedents, holding that law enforcement does not need a warrant to search a cell phone at the time of an arrest, upheld his conviction. The companion federal case arose with a completely different sort of technology because it involved a flip phone, not a smartphone. And many, many people thought that the Supreme Court would resolve this case relying on the distinction between what you can get off of a flip phone, which isn't much more than a record of the recent calls made, and what you can get off of a smartphone, which is a portal into the entire universe of data that an individual keeps about themselves. They did not use that distinction, and I'll come back to that in just a second. The Worry case, the Boston case, is a federal case involving agents observing what they thought was a drug sale from Worry's car, and later arresting him and using the call log on his flip phone to connect him to a residence where they located a stash of narcotics and some weapons. This resulted in a conviction, a very stiff sentence for Mr. Worry, a 20-year sentence. And the First Circuit Court of Appeals overturned some counts of his conviction because they held that nothing about the flip phone had anything to do with officer safety or the preservation of evidence, and that it should not have been searched without a warrant. And the Justice Department challenged that decision, and it came up to the Supreme Court. And stunning all observers, the Supreme Court ruled in a 9-0 decision that law enforcement indeed does have to get a warrant in order to search cell phones at the time of arrest. The opinion was authored by Chief Justice Roberts, and he held that absent some demonstrated dire emergency, like a missing, kidnapped child, a pending terrorist plot, a bomb threat, a warrant was going to be required. And even in those emergency circumstances, law enforcement would need probable cause and have to satisfy some judge ex post that indeed there were exigent circumstances that allowed them to get around the warrant requirement. Arguments in the case tended to devolve into hypotheticals about the possibility that arresting officers might be ambushed by arrestees' confederates who would alert officers to that ambush on the phone if it could only be reviewed, and about sophisticated encryption technology that would allow for remote wipes, tiger texts, zero date outs, things that could render smartphones unreadable if left too long in between seizure and a search of those phones. But the court was unmoved by all of those arguments and moved more by the simplicity of the technology available to law enforcement to prevent someone from accessing a cell phone that is seized. They're known as Faraday bags. They're basically little aluminum bags that you can stick a phone in so you don't have to turn it off and it can continue to receive data, but no one can wipe it remotely. So the court didn't really join issue over those arguments. Instead, it issued what is now known as its most privacy protective decision in decades, far more protective, for example, than its decision holding that using GPS technology, in the Jones case a few years ago, if it aggregated data over a month-long period of all of a suspect's whereabouts and movements, might implicate the Fourth Amendment and did implicate it if it involved a trespass. And I want to just highlight three issues about the opinion that I think are important. The first is that it sort of puts to rest a very old trope about the Supreme Court not being able to engage with technology. I myself have spoken about this in class and will have to refrain from doing so in the future. It is true that the Chief Justice still writes most of his opinions out in longhand. It is true that many of the justices, including sophisticated thinkers like Justices Kennedy and Scalia, have gotten confused and tangled up at oral arguments about what the difference is between paging and texting and calling someone on a cell phone. They have asked questions like, well, what happens if you get two texts at once? Is there a busy signal? Do you get both of them? Does it work like call waiting? They have asked questions like, can you print out the content of texts that you receive? Can you print out emails? There's been enormous discussion of the various ways in which the justices have demonstrated some technological confusion, and they've been accused of being troglodytes at various points. And it's probably true that the majority of the justices do not engage with technology at the level that you do, but just like your parents and your grandparents and their law clerks, they know a little bit more than we thought about what is going on, or at least they're willing to read and learn. There were many friends of the court briefs filed in this case, and many of them went to great lengths to describe the types of things that can be stored on smartphones. And the opinion that Chief Justice Roberts wrote recites those things at great length. The other thing that the opinion does is it approvingly gestures in the direction of Justice Sotomayor's concurrence in the Jones case involving GPS, in which she famously said that the volume of technology is changing at a rate that would require the court to bring its precedents up to date, and that some of their doctrines, like the idea that everything you knowingly and willingly turn over to third parties, such as by dialing a phone number, you have forfeited your privacy right in. And her point is that would apply to everything that you do on the internet. You cannot enter the modern world anymore without engaging with technology. It can't be the case that every time you do, you forfeited all privacy interests in the information that you exchange. And many of the justices seem to have now signed on to that notion. At oral argument and in the opinion, they repeatedly reference brave new worlds, different kinds of worlds. They seem to be alert, finally, to the need for new thinking about privacy given advances in technology. I'll quote just one thing from the opinion, which is the Chief Justice saying, in response to the government's argument that digital data is indistinguishable from similar physical items, because you could have a physical photograph, you could have a physical note, you could have a printout of a letter, you could have all those things in your pocket when you're arrested. Why should we treat it differently? Because it's on a smartphone. And the court responded, that is like saying a ride on horseback is materially indistinguishable from a flight to the moon. Both are ways of getting from point A to point B, but little else justifies lumping them together. So it's clearly a new era in terms of the court's understanding of the capacity of technology and the way in which it might infringe on privacy interests. The second really important thing about the opinion, and this is a more perplexing thing, is what it portends for the significance of warrants. Because the clarity of the court's holding, which many people attributed to the shortness of time between when the court heard the case and when it had to issue the decision, but you might attribute it to a certain clarity of thinking if you prefer to be more optimistic, it is that the warrants are required in almost every case. It's a fairly bright line rule, and there isn't a lot of wiggle room for law enforcement, absent those rare and extreme emergencies that are noted. But the role of warrants has been on the decline in Fourth Amendment jurisprudence generally. They, until now, have been increasingly confined pretty much just to the home, to buildings, to residences and offices. And they've had very little role to play in arrests, in car searches, in traffic stops, less and less so. And this is in part because the Fourth Amendment, some would say, doesn't require warrants at all. It protects against unreasonable searches and seizures. And then there's a separate clause that says, and no warrants should issue but upon probable cause. But in the opinion, the Riley opinion, the court repeatedly references the framers' distaste for general warrants and the revolutionary spirit that was ignited by the fact that the British were using warrants not as a protective measure, but as an intrusive measure in order to conduct general rummaging through the colonists' homes. And the court now seems to be resurrecting the idea of warrants as a privacy protection that might have a role outside of the physical space of the home. What's a little bit perplexing about that is that at the same time that it said, it's not that hard for law enforcement to get warrants. You can make a phone call to a magistrate, you can send an email, you can get an electronic one and search the phone very quickly. In contemporaneous cases, it has talked about how hard it is for law enforcement to get warrants. So the question is how sincere they are about this and whether the issue is just that law enforcement only has to get warrants when they can. And that if it's hard, they don't have to, which wouldn't necessarily be a very protective precedent. In your handout, you have some other references to other Fourth Amendment cases from the term, and you can see that the court split along more expected lines in some of those cases. And in some of them, you can see the much more inconsistent protection that defendants have received. So now I see the time always runs short in these things because these cases are so interesting. But the last thing that I want to say about this is just to situate it in the context of other decisions that have not been unanimous decisions, those split decisions. One theory of the criminal procedure decisions by the court is that they sometimes reflect a certain failure of empathetic imagination on the part of the justices, and that their decisions when someone is in court or needs a lawyer or wants to cross-examine witnesses are ones where that's a familiar environment for them. They can imagine being in court, they can imagine the import of a lawyer, and their reasoning follows suit. It's very hard for them to place themselves in the position of someone in the back of a police car, someone subjected to a Terry stop, someone being patted down at the time of an arrest, and as a result, they don't focus much on the individual experience, and they didn't in this opinion either. They were entirely focused on the amount of data that a smartphone could give law enforcement access to. But they do, as I've noted, increasingly use technology themselves, and so do the people who are related to them and who work for them and who they are surrounded by. And it was much easier for them to appreciate the significance of this particular intrusion than it has been in very recent, very similar cases involving things like taking DNA swabs from someone's cheek or strip searching someone when they're put into a county jail, because they don't have the imagination to sympathize with those experiences. What this all portends for those cases, I think, is probably less significant than what it portends for cases involving things like the NSA's searches of metadata, because that has to do with volume of information available through technological advance as well. And on that point, at least, the court spoke pretty clearly.
Thank you. So I'm going to comment very briefly on 3 of the cases decided last term, 2 of which were truly blockbusters, as to use Professor Griffin's terminology, and each of them marking a spot on three legal trajectories that one might expect to be quite similar to one another, but are actually quite different. And that's discrimination based on race, discrimination based on gender, and discrimination based on sexual orientation. First, in the race area, The case is the top case on page 5 of your handout. It looks like Schuett, but Professor Siegel tells me you pronounce that Schuette. So for a future word. Also, the other party here is not just the Coalition to Defend Affirmative Action, but this is really maybe the most fun thing I'm going to say. The Coalition to Defend Affirmative Action, Integration, and Immigrant Rights and Fight for Equality by Any Means Necessary, (BAM, B-A-M-N). That's the full title of that party, so I didn't make that up. So here the court is reversing a decision of the Sixth Circuit Court of Appeals, which and thereby upholding a state constitutional amendment banning the use of affirmative action in public education. As you can see, this is a 6-2 decision with 3 different opinions. Justice Breyer joining with the other 5 justices at the top. Justice Kagan recusing herself because she'd been involved in it when she worked in the government. So this case, I'm using, there's a lot of things we could say about this case, but I'm using it as representing a further chapter in a progression of cases in the race discrimination area that have gradually required increasing justification when state actors voluntarily wish to engage in race-based affirmative action. And this follows on the Fisher case out of Texas from last year. Schuette is arguably on a different track in the sense of it addressed not how far state actors could go to create more diverse educational institutions, but rather what limits a state, here the state voters, could impose on unelected state decision makers. So it's certainly framed as a much different case. But you can see the case, and the 2 dissenting justices saw it this way as part of a general and arguably highly regrettable pulling back with respect to the court's commitment to advancing racial equality. However you see the opinion, it's clear that there are 4 justices of the court who now reject explicit consideration of race either on behalf of or in the furtherance of racial minorities, rejecting it as unconstitutional. Justice Scalia identified the issue in Schuette as, quote, whether the Equal Protection Clause forbids what its text plainly requires. So, again, the man has a way with words. Chief Justice Roberts interprets equal protection in the race context in light of his very firm belief that race-based decision-making reinforces racism and can help, even when it's used in behalf of racial minorities, and it cannot help end it. Justice Kennedy has been the swing vote in these cases and writes the decision, and Justice Breyer concurs because he would give wide scope for voluntary affirmative action efforts, but he would not require them, which is essentially the theory you might think you needed to adopt in order to come out differently in this case. The second case, again, there's very brief descriptions. I'm going to try to pull them together or organize them in light of one another at the second half of my remarks. The second case, Burrell versus Hobby Lobby, you've heard of this case. It's very controversial, concerning whether a private employer can be required by the federal government to include coverage for various contraceptive devices in their employer-based insurance plans, as the Affordable Care Act, the ACA, required them to do, over the objections, the religious objections of a closely held family corporation. The court held that, yes, the ACA did violate the company's religious freedom rights under the Religious Freedom Restoration Act, which, as I believe, and Professor Young's going to say more about this case, the first time that a private company has been allowed to assert religious freedom objections to a generally applicable act of Congress. I mention this case in the context of the fact that while in the 1990s it looked like the court was headed toward working up a view of the reproductive rights of women as an equality interest protected by equal protection, the court in a couple of decisions now, one a 2007 case, Gonzalez versus Carhart, in which Justice Kennedy assumed for the majority that if women knew what they were doing, they would not make the decision to have a certain kind of abortion, and that women regret abortions when they have them, and thus they need to be protected from themselves. This Hobby Lobby case again, not a stunning example of this trend, I would say, but it's noteworthy in that the court put all the onus on the government in this case to show that the provision, the requirement of broad range of contraceptions and health, employer-based health insurance, the onus was on the government to show that this was the least restrictive means to accomplish its public health and sex equality goals without really any serious, realistic discussion of the importance of those interests from a gender equality perspective. Finally, in the most well-known case of the term, I believe, the court in U.S. versus Windsor held that a federal statute defining marriage to include only one man and one woman was unconstitutional as applied to two women who had a valid marriage under New York state law. This opinion merges rationales based, on the one hand, on federal deference to state law definitions of marriage, along with strong statements about the rights and dignity of same-sex couples who seek marriage. But its result, and especially much of its supporting language, puts it very much in the stream of a rapid rise in the growth of rights for persons with nonconforming gender identities and preferences. So the three trend lines I want to tease out, again, these cases, some better than others, represent these trend lines. One is in the race area, race-based affirmative action is subject to increasing limitations, with Schutte endorsing action by a majority of the voting public to eliminate a common method, and the dissenters would say a necessary method of addressing racial inequality, which is affirmative action. Two, an inability or unwillingness of the majority of the court to recognize or at least treat seriously the problem of sex discrimination, particularly in the reproductive rights area. I know Professor Young will love that. And three, that is, disagree with my analysis. Three is the lightning speed at which the rights of those with what I call non-conforming gender identities and sexual preferences are being established, with Windsor generally understood to mark a watershed moment. Okay, so I want to offer a few explanations for what seem to be these different tracks that race, sex, and sexual orientation are on right now in the court. First, I think their differences spring in part from the different nature of each of these types of discrimination. So I think it's fair to say that race discrimination is more deeply embedded within our social and political structure, more deeply embedded than, say, sexual orientation discrimination. It's easily rationalized by factors like merit and work ethic, important values in our society, and continually enforced by stereotypes which have been notoriously hard to change. Sex discrimination, in comparison to the other two, I would say is the more complicated to understand. Women are not a minority, and much of the discrimination, much of sex discrimination comes in the form of seeming favoritism toward women. Race stereotypes tend to be one-way stereotypes. Stereotypes about racial minorities are always bad, and about whites are good. Gender stereotypes work both ways and are based on some characteristics of women that are in fact unique to women. So this makes it different from race discrimination. So this complicates the operation of gender discrimination and thus makes society, I would say, more ambivalent toward its existence. By comparison, and again, by comparison, sexual orientation is rather superficial. It's based on an abhorrence of certain activities that some people disapprove of, but other than those activities, there's not a broad range of stereotypes that permeates all things to which people seek access, like education, employment, or participation in the political process. As a result of this, of all these factors, sexual orientation stereotypes have proved easier to break down. People, for the most part, can't hide their race or gender, and because these are deeply embedded, race and gender stereotypes have proved very difficult to change. Insofar as historically the main strategy of members of the LGBT community has been to suppress their gender identity and sexual orientation publicly, and so it turned out when the closet doors opened that everyone turned out to know somebody who was in this category, and they could see that these people were the same as the rest of us in their ambitions, their educations, their work styles, their desire and ability to form relationships and families, and so on. So oddly, in a way, this suppressibility, which is itself I recognize a controversial way of looking at it, but it's one way of looking at it. This has given the LGBT community the opportunity to overcome stereotypes that has not been readily available or so readily available with respect to race and gender discrimination. Similarly, race and gender are largely zero-sum transactions. Any step toward eliminating equality based on race and gender, whether it's admission to a university or a job, tends to result in someone else losing that opportunity. This is not true about the bellwether issue, which has caused the explosion of gay rights, which is access to marriage. Not that some people don't find their whole world changing because other people, same sexes, are getting married, but it's not the same kind of zero-sum game as is the case in most forms of race and gender discrimination. In part because of these factors, different standards of review, and those of you in their second and third years will know this very well, different standards of review have arisen in each of these areas. Race, as we know, has been accorded the strictest standard of review, such that once the court made the move of holding that discrimination in favor of racial minorities was just as suspect as discrimination in their favor, it became very difficult for institutions and employers, who wanted to do more to enhance race equality by developing affirmative action programs. It's become more and more difficult for them to do so. The court has never applied this strictest level of scrutiny to sex classifications, although they came fairly close in a case that successfully challenged a male-only admissions policy of the Virginia Military Institute. But because it's not used as the stricter standard, it has not had a stricter standard to turn on the affirmative action remedy that public actors might seek to use to enhance sex equality. It's difficult to say from any Supreme Court jurisprudence what the standard of review is in sexual orientation cases because they've chosen to decide, notwithstanding the briefs, chosen to decide all the important cases that have come, I guess all the cases that have come before them under other substantive due process grounds rather than equal protection grounds. A few circuits, the Ninth Circuit in particular, has found sexual orientation as well as race to be a suspect classification. Second Circuit talked about heightened review in the case Windsor that has come up before the Supreme Court. But this is really all to say that paradoxically, the standards of review that arose to try to end certain kinds of inequality, the stricter they were, as in the case of race, the more difficulty affirmative action has had standing up to that standard. So I just want to end with the one last factor, which many people would think is the deciding factor in these different trajectories, which is the difference that a single Supreme Court justice makes. Justice Kennedy is from California, not irrelevant, very accustomed to living and working with people with different sexual preferences. At the same time, arguably, he's been stuck in some gender stereotypes that cause him to think such things as that women should be protected from their own reproductive decisions. Kennedy's slot, you're all too young for this, but Kennedy's slot was supposed to go to Robert Bork, whom you've probably heard of, who we can be sure of never would have given us Lawrence versus Texas or U.S. versus Windsor. The second choice, Douglas Ginsburg, who's been on the D.C. Circuit. Similarly, we wouldn't have expected the decisions that Justice Kennedy has given us in the gay rights area from those justices, and that would make this comparison of these three areas look quite differently than it does today.
Thank you.
Justice Ginsburg Robert Ginsburg went down because he smoked pot in a previous life. And depending on how much, maybe we would have gotten some Kennedy-esque.
He was socially progressive on some areas more than others. Yeah.
So I'm going to start with the treaty power case and then talk a little bit about the religion case. Treaty power case is Bond versus United States. It was supposed to be a big case about the limits of the federal government's power to make and implement international treaties. It ended up being a little case about statutory construction. The facts read like an episode of Days of Our Lives, at least before Marlena got possessed by the devil and everything got really, really crazy. Carol Ann Bond is a Pennsylvania housewife who just happens to be a microbiologist who works for a chemical manufacturer. Her best friend Merlinda gets pregnant. Carol's psyched until she finds out that her husband is the father of Merlinda's child. At that point, Carol uses her mad chemistry skills to concoct a toxic poison that she applies to Merlinda's car door, mailbox, and the doorknob to her house. This doesn't work so great because it turns out the chemicals are highly visible, and Merlinda's like, I'm not touching that. So she gets a little burn on her thumb, but that's pretty much it. Fortunately, the cops catch Carol Ann on camera. They arrest her. She's initially charged under state law and likely to get 3 months to 2 years in prison. But a few months after the arrest, she's indicted on federal charges for violating the Chemical Weapons Convention Implementation Act. As the name suggests, the statute implements the Chemical Weapons Convention of 1993, which is a treaty of the United States that's aimed at, chemical weapons, right? Incidentally, on the federal charges, she ends up getting more than 6 years of jail time, which is more than 3 times the max she was looking at under state law. And that highlights one reason we're concerned about the overlap between federal criminal jurisdiction and state criminal jurisdiction, because federal sentences are a lot heavier. And what it means is that the main event that determines how much jail time you're going to do stops being the trial or even the plea bargain, but rather the prior decision made by the prosecutor about whether to take you federal. And that's pretty disconcerting. So Bond's case goes up to the Third Circuit, where the Justice Department talks them into a colossally dumb ruling that Bond doesn't even have standing to raise a 10th Amendment claim about the statute. That goes on up to the Supreme Court, which slaps it down 9-0. Case goes back to the Third Circuit. Now they consider the merits of Bond's 10th Amendment argument that this chemical weapons implementation statute exceeds Congress's power under the treaty clause. All right. The Third Circuit says, well, it doesn't exceed the treaty power, even though this was probably a weird case of prosecutorial discretion. You probably shouldn't have brought federal charges against this particular kind of person, you think? So it goes up to the Supreme Courts again to consider the merits. And everybody thinks they may overrule Missouri versus Holland, which is a landmark 1920 decision by Justice Holmes, which had said basically as long as you've got a valid treaty, then Congress can implement it with a statute, even if that statute goes beyond Congress's enumerated powers under Article I of the Constitution. A majority of 6 justices, though, all 4 liberals plus Roberts and Kennedy, ultimately chicken out on overruling Missouri versus Holland, and they decide that the federal statute doesn't really cover ordinary domestic feuds like bonds. Now, what makes this interesting is that the statute rather clearly does cover bond. It forbids any person knowingly, quote, to develop, produce, otherwise acquire, transfer, directly receive, use, own, possess any chemical weapon. It defines chemical weapon as a toxic chemical and its precursors, except where intended for a peaceful use. Toxic chemical is defined as any chemical which, through its chemical action on life processes, can cause death, temporary incapacitation, or permanent harm to humans or animals. The term includes all such chemicals regardless of their origin or their method of production. Finally, purpose is not prohibited by the chapter, includes any peaceful purpose like agriculture or research or medicine or something like that. So which part of toxic chemical don't you understand, right? On the other hand, it's equally clear that this is absurd, right? So at oral argument, Justice Alito asked the government whether he'd be guilty of using a chemical weapon if he poured vinegar into a fishbowl in order to off his kid's goldfish. And the answer is clearly yes, right? It's a toxic chemical that causes harm to an animal, right? It's within the statute. So the court says, look, we have a rule of statutory construction that says if Congress wants to intrude on areas usually regulated by the state, it has to clearly state its intent to do so. That's within, this case is within the ordinary realm of state criminal law. We don't think Congress has made it clear that it wanted to protect Carol Bond's philandering neighbor or little Phil Alito's goldfish in this statute. Supposedly, the statute is about using chemical weapons in war or terrorism. So Justice Scalia says in concurrence, wait, the trouble is, all of these statutory construction cases apply their clear statement rule only because there's some ambiguity in the statute. There's some term that it's not clear what it means or how it fits together. The clear statement rules tell us how to resolve an ambiguity that already exists, but there's no ambiguous term here. It clearly fits within the defined meaning of toxic chemical under the statute. Chief Justice Roberts is using the clear statement rule to create the ambiguity in the first place, which is not something the court had done much before. And here Justice Scalia probably wins the award for the best snarky comment of the term when he says that Roberts' opinion reads like a really good lawyer's brief for the wrong side. Except, Scalia ended up on the wrong side, right? Roberts wins this case. And I actually think Bond takes two pretty important steps in the court's clear statement jurisprudence, which tends to protect federalism not by striking acts of Congress down as going beyond Congress's enumerated powers, but by narrowing the breadth of federal statutes through statutory interpretation. The first step is that it makes clear that these pro-federalism presumptions in statutory construction apply even in foreign affairs cases, and that had been vigorously contested up until just a year or so ago. Second, it does seem to say that one kind of ambiguity you can have is when the clear language a statute uses appears to cover an obviously not intended application. Now, this idea is sometimes called the absurdity canon. That is, the ordinary meaning of a statute won't be followed if it would lead to an absurd result. And it actually has a little more precedential support than Justice Scalia is willing to admit. Now the court has basically said that intruding on the traditional powers of the state is the sort of absurd result that the rules of statutory construction ought to avoid. That's a pretty important holding. I think it's pretty easy to argue that the court's clear statement jurisprudence is the most successful part of its doctrinal efforts to protect federalism, and Bond may turn out to be an important case in that sequence. So I want to talk just briefly about the two religious liberty cases, Town of Greece and Hobby Lobby. If you're planning a honeymoon in Greece, make sure you go to the one in the Mediterranean and not the one in upstate New York, okay? The local town board in the town of Greece, New York, invites local clergy to offer an opening prayer before board meetings. The procedure for invitations is pretty informal. Basically, the initial list of clergy that are available is generated by a clerk going through the phone book, and then they take anybody else who wants to come around. For the first year, or first 8 years, all the invocations were by Christian clergy. At this point, somebody complains about that, and so they bring in a Wiccan priestess, a Baha'i leader, 2 Jewish laypersons. After that, things quiet down, and they don't have a whole lot of Wiccans in the town anyway to come in. The Wiccans have other things to do, so it's been Christians after that. And about 2/3 of the prayers mention Jesus explicitly. So all this gets challenged on Establishment Clause grounds, and the court treats the case as a rerun of Marsh versus Chambers, which was decided in 1983, which had upheld the use of chaplains in the Nebraska legislature. We also have chaplains in the U.S. Senate and the U.S. House. There's some really funny YouTube videos about the Senate chaplain during the budget crisis last year and just praying to stop, that God will stop the madness and knock some sense into these legislators. Professor Metzloff has an awesome video about the Marsh case, which I heartily recommend to you. Pretty soon he will surely have an awesome video about Town of Greece. This is probably an easier case than Marsh in many ways. For instance, the big argument against these prayers is they're sectarian. They're offered from a particular religious point of view. They're not generic in some sense. But the prayers in Marsh were also not non-sectarian. They were Episcopalian. Right? And they had the same guy permanently there for year after year after year articulating that one point of view. So I think in many ways this is an easier case, and the question is whether we're going to keep Marsh or not. And in saying that, the court says the question is not whether the government's really being neutral here. The question is whether it's gone too far and established a religion. And in that, we have to take into account precedents like the use of legislative chaplains. I think he says something interesting, Justice Kennedy, about the nature of the law in this area. He says, Marsh stands for the proposition that it is not necessary to define the precise boundary of the Establishment Clause where history shows that the specific practice is permitted. Any test the court adopts must acknowledge a practice that was accepted by the framers and has withstood the critical scrutiny of time and political change. A test that would sweep away what has so long been settled would create new controversy and begin anew the very divisions along religious lines that the Establishment Clause seeks to prevent. So in other words, Establishment Clause doctrine is the product of what John Rawls called reflective equilibrium. Right? Rawls says moral reasoning exists in a tension between theory and intuition. So we have theories about what's just, we have principles about what's just, but we also have intuitions about what's just in particular cases. And those may or may not fit the overall theory or principle. And so when that happens, we don't just necessarily give up our intuitions. We go back and forth between our intuitions and our theory, and sometimes we tweak the intuitions and sometimes we tweak the theory so it fits better with our intuitions. And basically this back and forth process eventually reaches an equilibrium judgment, reflective equilibrium. So the town of Greece, I think, shows that Establishment Clause doctrine is a little like that. We have some theories. We have non-endorsement, non-coercion, government neutrality, but they can't and they don't do all the work in the cases. We have to revise them and qualify them in light of practices that are settled and accepted. So Justice Kagan, in dissent, has a theory. She says the prayer at the City Council violates neutrality, but she can't really square that with Marsh or the longstanding practice of having legislative chaplains, so she picks the theory. Town of Greece could have been a lot bigger case. A lot of people thought that the court would have a different theory of the Establishment Clause, that they would say if there's no coercion, there just can't be an Establishment Clause violation. They don't do that. They say this is a practice that has been around forever. We have to qualify our theories to make sure that these things get to stay. I think that's both wiser and truer to the court's Establishment Clause doctrine, even if it doesn't play so great in theory land. All right, so Hobby Lobby. I only want to say a couple things on Hobby Lobby since Professor Bartlett has already talked about it. First, God help me, I think this is a really easy case on the law. It's not the first time that a private corporation has asserted a religious liberty claim. For instance, the Mormon Church, which was a private corporation, asserted a pretty big religious claim, during the Mormon persecutions in the 19th century, and nobody said that they weren't able to do that. Well-established precedents say nonprofit corporations have free exercise of religion rights. Well-established precedents also say that for-profit activities by individuals or sole proprietors can be the basis of a religious freedom claim. So for instance, when Jewish proprietors stay open on Sunday because it ain't their Sabbath, they're doing that for profit, but it's also religious exercise. Profit motive doesn't kill the religious quality of the act. So you put those things together and it's hard to see why the result would be any different for a for-profit corporation. And certainly for-profit corporations exercise other First Amendment rights. So even though the New York Times doesn't make a whole lot of money, I understand, they're supposedly a for-profit corporation and most people think they have free speech rights. Second aspect of that is that in order to say there's no burden, the RFRA requires a burden on religious free exercise. And there's some question of whether making the employers provide this contraception is a burden on religious free exercise. But in order to say it's not, you have to just disagree with the plaintiff's religious belief, that they're being required to collaborate with evil and that this violates their religion. And religious doctrine, or religious freedom doctrine, a lot of cases make it very difficult to resolve a religious liberty claim based on the idea that we just think your religious belief is wrong. And I think it would be dangerous to change that belief. And then finally, if Hobby Lobby can assert RFRA rights and exercise of religion as burden, then the statute applies strict scrutiny. And there's no way that the contraceptive mandate can pass any recognizable version of strict scrutiny. The reason why they don't talk about whether it's a compelling interest to promote women's health is because they concede that that is true. The case goes off on narrow tailoring. They say, look, the government, by framing the statute and exempting all the nonprofit religious organizations, has shown that it's easy to exempt people from the coverage of the statute and just pay for these contraceptives through other ways. And all that the government has to do to accommodate the religious free exercise of these plaintiffs is simply extend the nonprofit exemption to those very limited class of for-profit corporations that also qualify. All right? So that's why I think it's easy. I think the second point is the interesting question is, why is this hard? Why is it hard for the court? Why is it hard in the public debate on this case? Well, Justice Ginsburg says it's because the male justices have a blind spot on women's issues. I clerked for a liberal justice who voted with Justice Ginsburg a lot, but would have never thought it was appropriate to call out your colleagues and then accuse them of bad motives in that sort of way. But putting that aside, it's actually not a case about reproductive rights. There is no constitutional reproductive rights claim in this case, nor could there be. The Supreme Court decided in Harris versus McRae that you have a constitutional right to make choices. You don't have a right for the government to pay for them. And nobody has even gotten to the court arguing that you have a right to make other private actors pay for your contraceptive choices. So there is no reproductive rights claim in the case. It is a case about free exercise of religion, and I think arguably Justice Ginsburg has a blind spot about religion. Free exercise and religious discrimination used to be something that the liberal justices on the court agreed with conservative justices in caring about. For instance, Professor Bartlett, in talking about the kinds of discrimination going through these cases, doesn't even talk about religious discrimination, when religious discrimination is actually a lot like gender discrimination in that it's one of those areas where, in order to achieve equality, you may actually have to treat some people differently to give them an exemption from certain things, right? Liberals tended to criticize Justice Scalia furiously when he decided and wrote for the court in Employment Division versus Smith, which is the case that says that you don't have to give exemptions to religious people from generally applicable laws. The RFRA overruled that case. It passed by a unanimous House. Think about that for a second. A unanimous House. All the liberals, all the conservatives joined in supporting the RFRA. 97 senators voted in favor of it. That consensus has evaporated today. And Hobby Lobby makes it clear that the majority in Smith still has 5 votes, Scalia plus all 4 of the liberals, which is very surprising, right? Religious discrimination, the rights of religious minorities like the Mennonites in the Hobby Lobby are the reason why this country is here. It's the reason we got on ships and came here. And so it's frightening to think that the consensus across ideological lines in favor of religious liberty is breaking down.
Thank you. I know that Professor Bartlett, I'm sure, is going to want to respond, but I'm going to take moderator's privilege. I think we go to half past. There's a theme that was running through everybody's commentary, and I'm trying to link it together a bit. And I know this is kind of out of left field, but and it has to do with this issue that Professor Griffin had raised, but is also raised by the other 2 panelists, which has to do with empathy and the ability of the justices to feel somebody's pain or imagine, what it must be like to do X in terms of their decision-making, and either the distortions or lack of distortions that empathy raises in terms of adjudication. I would like the panelists to, speak, if they can, just a little bit about that issue, about empathy with respect to these cases, either as a descriptive matter, that is, decisions are being made either because of a lack of empathy or in excess of empathy, or as a normative matter, the sort of thought about what is empathy doing or should be doing in terms of the justices and how they make their decisions.
Well, empathy is one of those things you notice most when it's being exercised on behalf of the minority view, because to the extent that we buy into what all of the prevailing assumptions are of a society, some of which deserve protection, not to belittle them, but I mean, when you're figuring out who's exercising empathy, it's the big brouhaha came over Justice Sotomayor because she was talking about empathy on behalf of the group with which she identified, as opposed to the less visible interests of the majority. So there's no, I mean, the remarks I made about Justice Kennedy and his worldview, which saw gay rights in one way and maybe sex discrimination in another way. I think a number of these opinions reflect people's experience, which is, insofar as law is experience, is sort of exactly what we would expect. It's probably not very responsive to the question.
I want to change the word, actually, because empathy it loaded up in the confirmation hearings, and now one hesitates to pull the trigger on using that word. I think it's more like vision or imagination. Okay. It doesn't necessarily require feeling. It requires analytic ability. And that's sort of what I was referring to when I referenced difference between the court's logic when it comes to the privacy invasion of looking in a cell phone versus a strip search or DNA. So, I mean, DNA is a portal into genetic privacy that could potentially reveal information as intimate and damaging as whatever you might find on someone's cell phone. But for whatever reason, that's a Maryland versus King is a 5-4 decision, and the cell phones are 9-0. And I think it has something to do with understanding not what it feels like to be in that position, but what it portends for the person who is in it, which doesn't mean that you have to put yourself in their position. It means you have to have a sense of it. Justice Stevens, I think, is the most profoundly empathetic justice of the modern era, and he, I say that because he wrote a lot of opinions where he clearly had a vision of what it was like to encounter police in a disadvantaged neighborhood, what it was like. This is not within his experience, it's just who he was as an intellectual. So I think I might want to say imagination rather than empathy.
Okay.
I think the hardest kind of empathy to have is empathy with people who profoundly disagree with you. And I think the reason why Justice Ginsburg's remark so fundamentally offends me is because it shows a basic lack of ability to appreciate that the people who are on the other side of a case from you might think they've got pretty good arguments, might not be because they just didn't understand your point. Maybe they just disagreed with your point, right? And it's a failure to confine the debate to just an argument on the legal merits rather than impugning the motives of the people on the other side. And I think that's really, really important. And one thing you see going through these cases is there's, this will shock you when I say this, but there's a threat of federalism here. In Schuette, basically, the question is whether it's constitutional to decide something at the state level rather than the local level or the national level. Right? That's the actual constitutional claim that's being made. And the majority says, it's constitutional to have states and let states be able to make up their mind. But one of the byproducts of that is that different states get to come out different ways on things. So Massachusetts may have a lot of affirmative action, and Michigan may decide that they're not going to have affirmative action. And the court uses federalism in these areas where we just fundamentally don't agree yet about whether it's right to have affirmative action or not. Same thing, because then different states can decide it differently, and people can live together a little more easily because they can pick a jurisdiction that suits them. Same thing about same-sex marriage, right? In Windsor, the courts, all Windsor says is that the federal government can't impose a definition of marriage on the whole country, right? And it respects the definitions that are decided on at the state level. Now, maybe the court is going to decide there is something, the Constitution requires a particular answer to that question, but it hasn't decided that yet. In the meantime, it's given some good language both ways. And in the meantime, we get to try it both ways in different jurisdictions and see how political opinion moves, which it is moving, and I think very effectively. But when you can appreciate that the other side has some legitimacy to it, then you can accept that sort of resolution.
I'll open the floor to questions. Anybody have? Yes, sir.
With regards to the Schuette case, when West v. Bollinger came down, they said Senator O'Connor put that 25-year test on the affirmative action, and then we'd reassess it. Do you think it's around to stay based on the composition of the court, or it's going to be completely, I'm talking about race-based affirmative action, overruled in the near future?
So the question is about the 25-year window that O'Connor wrote when she wrote Gratz and Grutter, as to whether it's going to stick or not. I think that's the summarize.
25 years hasn't passed, but it's a retreat. Yeah, so, I mean, the whole. I agree with Professor Young to a point that this was all about who gets to decide what among various measures one might want to use to enhance racial equality, which ones we're going to use. The whole I mean, what the dissenters would say to that is the whole idea of equal protection law was to keep the majority from engaging in practices or passing laws that were discriminatory against minorities. So, I mean, I think those two things are sort of what's have to be looked at together. And on this one, Justice Breyer goes with the sort of federalism point on the theory that we want to let actors who wish to engage in voluntary affirmative action. He would be more liberal than the majority of the court has been on how strict standards should be applied to that constitutionally. But on the other hand, as Professor Young said, if the state decides it's going to rule that out of bounds, then we'll let them do that too. What if it's true though? So this reflects two very fundamental differences about how you decrease race inequality or how you enhance racial equality. What if it's true that the dissenters are right? They might be wrong, but what if it's true that they're right, that we're not going to make any progress whatsoever without affirmative action? Then Robert, the Chief Justice, is convinced we're not going to make any progress if we do engage in race-based preferences, and other members of the court. So there's a sort of an empirical fact about which there's a profound disagreement, which causes the tension on this issue to look very different. I don't know anything about. I don't know how the future will develop on this. I'm not much of a predictor.
One last question.
I just have a quick question about McCutcheon. So given this case and Citizens United a few years ago, do you think the court has sort of set itself on a trajectory to where they're going to soon be overruling the individual limits?
Why are you all looking at me? I don't know from campaign finance.
You're the only one who would possibly know the answer to
The
that.
question is whether there will be basically a ruling that unlimited campaign contributions, is that what we're talking about? From an individual. Look, it's hard to not look at this line of reasoning and say if money is speech and this is a government restriction on money, then then by the syllogism it's a government regulation of speech. I mean, that's a pretty old saw about how people sort of think through it. That being said, there is still the prohibition against express quid pro quo, and to the extent that I give you this much money, and lo and behold, X happens afterward, becomes, the touchstone for what is potentially prescribable. The question is, do you have to just wait till it happens and then prosecute it after the fact, like it happens now, or can you take some sort of remedial, or preventative action through the campaign finance laws? And I don't know where we're going to go with that. I think our time is up. Thank you very much for attending. Thank you for the panel.